Hey, I'm Paul Rabelais, and in this video, we're going to talk about, in simple and easy to understand terms, what it means to make a gift to a Crummey Trust for a family member. Okay, so I'm estate planning attorney Paul Rabelais. It's the end of 2019 at the time that I'm making this video, about the time when I get asked to make lots of Crummey Trusts. We're working on these in our law office for several of our clients at the moment. So let's just lay it all out in easy to understand terms, and to really understand it, I got to give you the background. Okay, so, and really this is important if really at any time during your lifetime you plan on giving someone maybe $15,000 or so. Even though I'm going to be talking some big estate tax dollar numbers, if you plan on making even small gifts, you need to be aware of how all of this works. Okay, so let's go to the background. In 2020, the numbers just came out, the estate tax exclusion amount is $11.58 million. That's a big number. I know some of you, many of you, most of you watching this video may be thinking to yourself, I'll never have an estate that large. And you're probably right, but you still need to be aware of the content of this video. Nonetheless, 2020, $11.58 million. It does revert back to $5 million adjusted for inflation in the year 2026, when our 10-year increase in the estate tax exclusion amount sunsets on January 1st of 2026. So that's a big change. Okay, and the way the gift and estate tax works, it's what I call unified. It's the gift and estate tax, meaning that $11.58 million exclusion amount, somebody can use it either during their lifetime by making gifts, or they can use it when they die by leaving an inheritance. So let me give you an example. Estate tax exclusion amount, $11.58 million. During Grandpa's lifetime, he gave away $1 million. So because he gave away $1 million during his lifetime, he used up $1 million of his $11.58 million exemption. So when he dies, he can only leave $10.58 million instead of $11.58 million to his heirs. So you should be starting to see how this gift tax and estate tax works together. Okay. So in addition, there's another rule called the present interest annual exclusion. And for 2019 and 2020, the applicable number is $15,000. I'll call it the $15,000 present interest annual exclusion. The rationale there is the IRS probably doesn't want to keep track of the $500 gift, the $1,000 Christmas gift, the $2,000 birthday gift that you give to your children, to your grandchildren every year. So they say that the first $15,000 that you give to someone in any particular year, it doesn't count toward your exclusion amount. So many people do give $15,000 to their children, to their grandchildren each year, and they never tap into their exclusion amount because they never make a gift in excess of $15,000 to anyone in any one calendar year. Okay, so here's where we're warming up to this Crummey Trust stuff. But many people, grandparents in particular, you know, they don't really like the idea of writing out a $15,000 check, or maybe a married set of grandparents writing out a $30,000 check to their 11-year-old grandson, 19-year-old granddaughter. You know, they don't feel right about that because those grandchildren haven't, fully matured yet, and the grandchildren might mess up and use the money for the wrong reasons. So many people, when they do make gifts, they want to make those gifts to a trust. I'll use the grandparents as an example. Grandparents make a gift in trust to each of their grandchildren, $15,000 per grandparent, $30,000 for the grandparents to each grandchild, but they put it in a trust. Perhaps they name their daughter, who's the mother of these grandchildren. Perhaps they name the daughter as the trustee of that trust. And the trust terms probably say something like the trustee can use the trust assets for the beneficiary or grandchild's health, education, maintenance, and support. And then when the grandchild reaches age 25 or age 30, or maybe it's at the trustee's discretion, then the trust will terminate and any remaining trust funds can then go to the grandchild or the beneficiary. Okay, so here's where it gets tricky, and here's where you can be a real expert on this matter if you follow me. Okay, our $15,000 rule, it's called the $15,000 present interest annual exclusion, with emphasis on the words present interest. To take advantage of the $15,000 that doesn't count toward your exclusion amount, you have to give those donees, or the people you're giving money to, a present interest in the gift. By putting it in a trust for them to get later, you're giving them a future interest in that gift, which doesn't qualify for the present interest annual exclusion. So by putting it in a trust for them to get in the future, by making a gift of a future interest, even if it's $15,000, you're starting to use up some of your estate tax exclusion amount. But there's an exception, and that's where we get into the Crummey Trust. All right, so this started a long time ago, where it was back in the 1960s, a court case, I guess, with the IRS. And there was a guy by the name of Clifford Crummey, C-R-U-M-M-E-Y. I wish he would have had a better last name, because now he's got, this stuff named after him. But nonetheless, more power to him. If you're famous for something, you might as well be famous for making Crummey Trusts. Okay, so here's the way it works. You can get around this gift of a future interest by the traditional set up the trust for your grandchild, put the $15,000, or the couple puts $30,000 into the trust account, for the grandchild. And then the grandchild or the beneficiary of trust is given a period of time, typically 30 days, within which they can withdraw the money or take the gift. That may not sound too good for you, but stick with me. And if that 30 days goes by and they don't exercise their Crummey withdrawal right, then the funds just stay in the trust, subject to the terms that are described in the trust instrument. Now, the good news, you might be thinking, the bad news is, you mean I can put money in a trust for my 19-year-old granddaughter, and I got to go to her and say, here, for 30 days you can have it. But if you don't take it, it's going to stay pursuant to the terms of the trust. Your mother will be the trustee, and it'll be used for education, and you'll get it, down the road. So, and I say, yeah, you gotta give them that Crummey power. But the good news is, personally, I've never ever seen a beneficiary exercise their Crummey withdrawal right. Probably because there's a conversation between grandpa and granddaughter at the time he makes the gift. Granddaughter, here's your right, here's your Crummey notice where you have a right to take these gifts for 30 days. I plan to do this every year, and every year you'll get a notice. And you know what, granddaughter, if you exercise your Crummey withdrawal right this year, I'll never make another gift to you in trust or otherwise ever again in the future. So, most beneficiaries are gonna kind of put two and two together and say, wow, that's really nice of grandpa to put $30,000, grandpa and grandma to put $30,000 in a trust for me. I think I won't exercise my Crummey withdrawal right, because if they're going to keep doing it every year, that could accumulate to be a pretty good amount. And oh, by the way, my mother, who's the trustee, the granddaughter's saying, is she can use that money for my college and for other needs that I have, and then I'll get it down the road. So the having to give the Crummey withdrawal right kind of scares donors at first, but then when they really realize that it's unlikely for a beneficiary to ever exercise their Crummey withdrawal right because of the future consequences to that beneficiary, then most donors, most grandparents, most people setting up these Crummey trusts say, okay, well, we can live with that. So these Crummey trusts, they're set up often by parents for children. They're often set up by aunts and uncles for nieces and nephews. And then probably the most common scenario is, grandparents who have accumulated enough assets where they know they're going to be comfortable for the rest of their lives, and they can, quote unquote, afford to part with these annual exclusion amount gifts every year without jeopardizing their right to live comfortably for the rest of their lifetime. And it's common for grandparents because grandparents often make gifts to grandchildren, and grandchildren are young and oftentimes irresponsible, just not grown up. And so it needs to go in a trust for the grandchildren. Often when grandparents make gifts to their children, the grandparents might be 70, the children might be in their 40s, and those children might be responsible enough for the grandparents to just say, okay, child, I'm just going to write you a check for $30,000. That's your gift, but I'm not going to write a $30,000 check to your grandchild. I want it to go in a trust for them. So real common for grandparents to set up these Crummey trusts for the grandchildren. So if you want to make gifts in trust instead of outright, and you want to be able to take advantage of the present interest annual exclusion, then you're going to want to make sure you set up a Crummey Trust for that beneficiary and give that beneficiary those Crummey withdrawal rights, and then probably have that conversation on the side and to say something like, don't you dare exercise this withdrawal right that you have for 30 days, because if you do, you'll never get another penny from me. Okay, so that pretty much sums up the Crummey Trust, the Crummey withdrawal rights. Might have to watch this one or two times to really understand it, because it seems like the first time it's explained to someone, they don't fully get it, but maybe the second time, the third time, kind of the light bulb goes off and they start to get it. All right, so, and you see a lot of this in December because once the calendar year is up, you lose your opportunity to make gifts for that calendar year. So we see a lot of this Crummey Trust activity in November and December each year. Okay, so I'm Paul Rabelais. I'm a estate planning attorney. Hope this helps. We'll see you next time.